Okay. Well, I guess we'll start to get started. Um, I'm Steve Gilson with the Alliance for Southern California Innovation. We are recording this session for posterity and to be used for those who cannot attend, or just in general. We feel like this content will be amazing, sort of evergreen for quite some time. Um, um, okay, sorry. One of our speakers I will work on in a moment. We're joined by Mason Fessian, who's an associate at Wilson Sonsini, one of the preeminent law firms help basically build Silicon Valley and the tech industry as we know it. Not Mason exactly personally; he's not that old, but that firm is quite established. And Mason, I'll let you introduce yourself a bit more about what you do. But I'll just give some housekeeping notes here. Um, Again, this is a webinar, so none of your cameras or mics will work. You're all attendees, and so just the speakers will be on screen. And if you have a question, please throw it into the Q&A. We will try to answer some of those during the sessions as much as possible. And then we will, at about 1 o'clock, we'll actually break for formal Q&A period. And then that's when we'll have, if you have a question that you want to ask, you put into the Q&A. We will then we'll read Brian over here from Nucleate, and I'll let him introduce himself in a minute. We'll basically flag those questions that we think should be answered in the time we have. Hopefully, have time for all the questions, but he'll be monitoring those, and then either read them out loud to Mason and Ruben who will join us in a moment. Or we'll actually promote you to be a speaker, and you can actually ask the question on screen. We'll see how that goes, and see how quickly we can get through those questions. Obviously, we want to, a lot of questions to make sure we have time for everybody to ask those questions, and that's how we'll run it. I'm going to pass over to Brian from Nucleate to introduce what Nucleate does. Some of you who are here may have heard about this from Nucleate. If not, you should learn more about it. It's an amazing organization. And I will let Brian say what it's all about.
Awesome. Thank you for the intro. So my name is Brian Gerber. I'm a fifth-year PhD student at Caltech. I'm also one of the co-managing directors of Nucleate Los Angeles. Nucleate is a student-run nonprofit that helps translate technologies out of university labs into startups. We do this through a program of expert workshops and mentoring. So if you're a student, postdoc, early career scientist within an academic university that's looking to transfer some of their intellectual property, patents, as proof of concept on research into a startup and want some guidance on how to do that, we're here to help. Also, if you're an industry professional who's interested in engaging with students, we have ways of doing that. One of them is through mentorship. So you meet with the students, once a week throughout the duration of the program, or you could be an expert in a workshop. So you come in once via Zoom for 2 hours, and meet with 2 teams, hear their pitches, and give direct feedback. So if anyone's interested, I'll drop my email in the chat, and feel free to reach out to me. And again, I'll be moderating the Q&A, and I'll mostly read everyone's questions out at the end. Cool.
Great. Thanks. Thank you, Brian. So yeah, thank you for all your support in this and guidance. And I also want to mention that this workshop would not be possible without the support from Michelson Institute for Intellectual Property. And unfortunately, they could not be with us today. But they are full support. They had another conflicting meeting, but I want to read a little bit about the Michelson Intellectual Property Institute. So they are, since 2016, Michelson IP has been dedicated to empowering the next generation of innovators and creators with free access to intellectual property resources that touch on the fundamentals of patent, copyright, trade secret, and trademark law. As you begin to develop your brands, businesses, and new ventures, you'll find that an awareness of IP becomes increasingly important. As such, we invite you to visit the resource hub at michelsonip.com to learn more. So yeah, Michelson IP is a great partner with ours. And in fact, this recording will live on at michelsonip.com at the resource hub. So after we're done with this recording, we'll edit it and it'll post it there. And there's lots of other great resources for entrepreneurs and founders and inventors, and anyone who's interested in having access to more IP resources. And we are now joined by Ruben. Hello, Ruben. How are you?
Here I am. Made it. Thank you.
Great. Sorry, Zoom issues. So great. So in the interest of time, I want to get started. So I'm going to basically first is going to go Mason. We'll talk about a little bit about the legal aspects of this of IP and sort of protecting intellectual property. And then Ruben will come next and talk more about sort of licensing, especially out of a university setting. And I'll allow you all to introduce yourselves then. So then at the end, around 1 o'clock, we'll start the Q&A. So Mason, I will throw it over to you, and I will spotlight you, and you can share your screen, and I will get out of the way. Right.
All right. Thank you, Steve. I think everyone can see my screen, and hopefully everyone can hear me. And I know there's a lot of material to go through, so not so much time. So definitely, I don't know if we'll be able to handle questions live. We should reserve those for the Q&A session. But I definitely want to make sure everyone is following along and paying attention. So I do have eyes on the Q&A, and if at any point, if someone hears a phrase that they're not too familiar with, or just anything unclear, please try to enter it in, and I'll try to work that into what I'm talking about. But pleased to meet everyone. My name is Mason Passian. I'm a licensed patent attorney at Wilson Sonsini, Goodrich, and Rosati. As Steve mentioned, the firm has a long history in supporting early stage, emerging, innovative companies. My role specifically is a patent attorney. So my background is in immunology, and I tout a little bit of neuroscience. Prior to law school, I worked at an oncolytic virus company, trying to cure cancer. And then I moved over to law school, and now I support companies like the company I used to work at in raising funds and eventually, putting products on the shelves and saving lives. But that background and the background of all my colleagues, both in the patent group and the other kind of groups that Wilson Sonsini has under their life science team, really manage every aspect of starting the company, growing the company, and then the eventual exit. We have I don't want to spend too much time on the marketing materials, but you can look us up. We have quite a bit of experience in this space, specifically the life sciences space, where on top of all the we see the majority of deal flow in this space, both on if aggregating the company side and the investor side. Again, the team that I work with, we bring a very strong technical background. A lot of my colleagues were people like Brian not too long ago, still completing their finishing up their postdocs or their actual degrees. And now they're bringing their technical expertise over to our firm to pass that on to all of you folks. So what I want everyone to walk away with today is a basic understanding of how to put together an effective IP strategy, a strategy that when an investor sees your portfolio, they think to themselves, okay, this is a company that knows what they're talking about when it comes to IP. They're leveraging their IP in the right way. So let's begin. What is a patent? This is the front page of a patent. Looks like this. This is an issued patent. Has some names, title, usually a figure by choice, and this it's a piece of paper really, or nowadays it's just electronic. There are still printed versions, but it's a piece of paper. And what does this patent do? This patent is a government granted right to exclude others from making, using, offering for sale, selling, or importing into the United States the invention. What is the invention? What is the enforceable aspect of a patent? It's going to be the claims of a patent. And as I mentioned, it's importing into the United States, making in the United States. So every country is going to have their own patent system. But the exact function is, again, this exclusive right to exclude the claims. So when you open these patent applications, if you get to these issued patents, at the very end, you're going to see these enumerated sentences from 1 to 19, 1 to 100. And this is at the very end. It could be a 50-page patent. It could be a 100-page patent, 200-page. At the very end, you'll see these numbered sentences. These numbered sentences are the claims. You cannot, if a claim states something, if an issued claim states something, no one but the owner or a licensee to that patent can make, use, sell, import into the United States what's covered in the claims. The entire rest of the application is simply written to support these claims, these words. This is what it's all about. Sometimes these words don't really look like English. They have words like a plurality and disposed over. You need to describe the structure. So you're going to see some weird words, and we're trying to be as broad as possible. So sometimes we make our own words, really, to keep that breath. But the point here is that we need to get to issued claims. That's what our enforceable right is. Now the question begs, what's, why, if we don't like monopolies, why, and we want to spurn, innovation, why are we allowing people to kind of exclude others from doing these things? So the theory behind all this is it's a bargain. It's a bargain between you and the public. If I put, my invention, if I describe my invention in a patent application and disclose it to the public so everyone knows how to use it, then the government says, okay, thank you for advancing society, advancing the public. We're going to give you a temporary monopoly over your invention. This all comes together to kind of create a business strategy. If you're putting your ideas out there in the public, and you can utilize a 20-year monopoly, then you can, that'll inform you of how you can structure, how you can time your publications, time the technology you're putting out there to increase, to maintain your monopoly over the industry that you're in. That's the entire essence of an effective patent strategy, or a patent strategy that's going to get you funded. How can you use your strategy? How can you use your IP to maintain your competitive advantage? As we know, as Steve briefly mentioned, there are various forms of IP: patents, trademarks, copyrights. But for innovative companies, patents are going to be by far and away, your most valuable piece of IP. There's a nice little kind of simplified story there at the bottom of the slide where, you may have a catchy name, you may have a really catchy name for your drug, but it turns out, let's say someone else has a trademark to that name. You can definitely think of a new name, but you're not going to be able to, synthesize a new chemical or completely change, the structure of the antibody. You use a patent to protect those things. So would it be possible to turn up? Steve, do you know if we have that technology?
To do what then?
To turn on closed captions.
I don't think that's a Zoom feature that I'm aware of.
Yeah, sorry about that. Sorry about that, Rochelle. But anyways, the patent is what's going to stop people from replicating the technology. Copyrights, trademarks, they will give you offer some sort of protection. But for an innovative company, you want to stop people, you want to exclude people from replicating the technology. Now, this is of course different. If you were an apparel company, then your value is going to be in potentially your name, your mark. Perhaps patents aren't the answer for an apparel company. But for an innovative company that's putting technology out into the public, you want to utilize your patents. So we kind of keep going back to this idea of what do investors want to see? What kind of patent strategy is gonna make your company look good? Is gonna get you funded? This is what we do here at Wilson Sonsini. We diagnose, analyze our clients' patent portfolios, and we get them ready to present to investors, because we know investors are always going to ask these two questions. How is this company utilizing the IP to maintain its competitive advantage, both near term and long term? And then secondly, will this company get shut down due to another company's IP? These are, when someone brings up IP strategy, what's your IP strategy? What's your patent strategy? These are really the two things that we need to be thinking about. How do we protect ourselves and how do we not get sued? These, from the company perspective, patents bring patents really, enable, the company is able to answer those two questions with an effective patent strategy. And it's the patents that allow for, earlier I said it's a temporary monopoly, but with a proper patent strategy, you can take, for example, Humira, the arthritis drug Humira. They have 127 patents and counting, and they've had patent coverage over the drug for over 20 years. And one way to do that is with a very effective patent strategy. We'll get into how you can do that, but overall, it's an effective patent strategy. And it's things like that when an investor is coming and talking to you on day one, and they're thinking, oh, you might have one patent, and you're going to be posed with questions of how are you going to continue to innovate? Where, how close is your current technology to the thing that you actually see going into people, or the device that's actually going to make it onto the shelves? How can you utilize in your IP strategy to continue building patents to go over that initial 20-year mark? And conversely, again, what's your knowledge base of your competitors so that you can assure, at least maybe not assure, but instill confidence in investors that, hey, I'm aware of the space and we're not going to get shut down. We're going to keep going back to these 2 points throughout the entire presentation. But how do we protect ourselves? How do we increase that 20-year mark? It involves, again, an effective patent strategy. You can't make two different patents on the same thing. You can't have two patents with the same exact claims. They can be similar, but not exactly the same. So it takes, this is where patent attorneys really, kind of, show their value, bring in their value. It's not the craziest thing in the world to take someone's manuscript draft and turn it into, some sort of paper that'll get you some sort of coverage on your product or what's being described in the manuscript draft. The key analysis and the largest value add is going to be putting together a long-term strategy, putting together something that is going to enable your business to, again, maintain that competitive advantage for over 20 years, 50 years, 40 years. And that takes an alignment with both the technical team and the IP strategy personnel to time everything properly. Now, I'm just again breezing through these things, but I talk about timing, and we talk about patent applications are it's a bargain of what you're putting into the public versus this temporary monopoly. We can spend a whole college semester on a whole university semester on the requirements for patentability, but for putting together an effective strategy, and what I want you guys to understand for today's meeting is that generally, your patent needs to describe what you're claiming. So the rest of the specification needs to support those claims, and it needs to be new. Those are the two primary takeaways. And that last one, the fact that it has to be new, is where a lot of people who work at institutions, or people, even if you don't work at an institution, you're just at a very early stage startup, there's always going to be a kind of a conflict between, hey, I don't have the money to patent something, and I need to publish, or I need to publicize what I'm working on so that I can get money to start, building my company. It can be a catch-22 at times, but biggest takeaway here is do not become your own worst enemy. I said that a patent application, what's being described in a patent application must be new, right? There's two ways to describe new. Either can you put 2 or 3 things together to arrive to your thing? That's the most common kind of rejection. And in rare instances, the examiner might point to one reference and say, hey, everything that you described is already being done here. Now, the reason I'm saying don't become your worst enemy is in those 2 scenarios, oh, we have 3 things that lead to your product, or here, everything you've described is in one thing. The most likely way of finding yourself in that second situation, which is a very bad situation, is when you put out your own work. There's no one out there that's going to be as good at describing your invention as yourself. So if you, and this happens it used to happen more often, but I feel, and Ruben can maybe comment on this, but I feel like university IP offices and tech transfer offices have been getting a little bit better at protecting everyone's IP rights, because where this critically comes into play are at universities, where perhaps the lab personnel, including the PI, don't have that open and transparent dialogue, or such an easy dialogue with the tech transfer office. And there's such a focus on publishing these robust results that have taken, years to synthesize and formulate, that the IP practice falls apart. I showed you guys this slide earlier that, how can you create this effective patent strategy to get past the 20 years? This whole thing can fall apart if before family number 1, there's a reference that completely predates it. Each of these families get filed, at a certain time, such that the previous family can't be used as prior art. When you first file an application, it takes 18 months for it to publish. So if you file anything after, or if you file anything before the 18 months, the first thing can't be used against you. But if you're at a university and you publish a paper and it publishes, there's no 18 months, it's out there. And now anything after that date is going to be subject to being tested against that publication you put out there. So suddenly this nice, linear kind of relationship begins to fall apart, even before it ever started, unfortunately. So how do you combat against that? It's, if you have control, just file a patent application. It's very cheap to file provisional applications. It is very cheap to file provisional patent applications, and they're not tested. At a worst case scenario, you can at least take what you're going to publish and put a cover sheet on it and put it in an application. That's at a worst case scenario. We want to do better, but sometimes, even at a sophisticated law firm, sometimes we get clients that come to us and say, hey, we're about to go into these discussions tomorrow. It's a big opportunity for us. Sorry, we didn't give you a heads up. We didn't think it was happening. Or, hey, we have a press release next week. In those situations, even us, sometimes we just take the material and we just put a cover sheet on it and file it. That'll cost really no more than $1,000. If you're doing it by yourself, it'll probably be less than $1,000. And the protections it offers are immense. I would, if we have more time, I'd like to go through all of these kind of tips and tricks to not, do not become your own worst enemy. But I did want to kind of burn through a couple more high-level topics that gets you, thinking about how do I put together this overall strategy. So, and real quick, I will take this question: patent term extension up to 5 years, beyond the 20 years, only up the length of time. FDA for persecuted, don't worry about lawsuits. So I'm not sure what the question is, but so for FDA, for regulated products, there's a label, right? Eventually when you put that regulated product on the shelf, there's going to be a label. And on that label, you're going to have an opportunity to list patents that cover that product. You're giving an infringer, by doing that, you're giving an infringer notice that, hey, this patent covers this product. If you're going to copy this product, you're going to infringe this patent. And if someone still does that, they may be on the hook for willful infringement. And that creates that creates 3 times damages. It can be very bad for a company. That's how you can actually cripple, that's how IP can cripple a company, is if you infringe someone's patent and it comes out that you knew you knew it was covering the product and you did it anyways, and you owe 3 times the royalties, that can cripple a company. You can pay royalties on something because you're still going to be making profit, but 3 times royalties can start throwing those numbers off. And anyways, that's the label. You can select 1 patent on your label to extend for up to 5 years. So that 5-year extension, this 5-year extension is completely independent of going beyond the 20 years just based on your own procedural filings. This is a one-time kind of only for therapeutics and FDA regulated products, that it's a special case. And it's, again, as you mentioned, it's only up for 5 years. Using this effective filing strategy, you can, again, push this out for 40 years, 50 years, depending on the nature of your product. So very quickly, I want to discuss, the second part of all this, which is being aware of your landscape. And landscape analyses, competitive landscape analyses, it's a function. It's a function of the maturity of your company. No one's going to be expecting you to know the entire competitive landscape at day one. If an investor is coming to you with $50 million, then there's an expectation. There will be you can expect to have a very sophisticated IP law firm asking you very tense questions about other people's patents, and anything in between that. Kind of just, it's a case-by-case basis. So I've given, an example, I've given several examples of what types of, what types of searching can you do. In all these different types of searching, what you're looking for is an issued claim that covers your product. As we talked about earlier in this presentation, only issued claims are enforceable, right? So, and I kind of listed these in order of like least sophisticated to kind of most sophisticated. If you're very early on, and again, you don't have the 50K, or don't really need to spend the 50K to do an exhaustive search. One idea is, hey, if we filed IP ourselves, let's at least look at any patents that were cited against us. Now, that's reassuring in some ways, because look, you can say, hey, this was an independent third party's opinion on what other patents, what other technologies are similar to our technologies. So you can look at those references, see if any patents have actually issued from those references, and then assess whether they would block your company. Another example would be if you're in the device space and you're telling investors that your regulatory pathway is a simple 510K, you should perhaps be ready to look at that predicate device's owner and make sure that they don't have any IP that would block your device. Again, it's about instilling confidence in the investor. So if you tell an investor, hey, we got the 510K, I've already looked at Pfizer's or Roche's patents, and we don't infringe it. That's a solid story. Lastly, just another example. If you're in the space of designing a recombinant protein or some sort of recombinant gene, you can use there are free softwares. It's almost like PubMed, and actually utilizes PubMed to look at all the published patent applications and compare your sequences to these patents to everyone else. So these are the type of searching that at a certain level of sophistication, an investor is going to want to see that you've covered these bases. Now we'll come back to this, but I did want to highlight a side-by-side difference between, I keep saying issued claims. What you see on the screen here is a pending application. And the way to tell is if you look at the number, the pending applications are always going to start with the year. That's the year that the application was published. It's important to note this because a lot of early stage people just don't really quite understand this. The claims of a pending application are not tested. So they can literally say anything. And remember, only issued claims are enforceable. So that's an important, simple, low-hanging fruit takeaway that I would like all of you guys to walk away with this meeting with. Conversely, an issued patent is going to have some sort of, a number in the millions. Good question here. Do you need a patent search for filing a provisional patent application? Look, so it's about a balance. Okay, it's about a balance. We talked about the requirements to patentability here. You want a worst case scenario is if you spend 15K and it turns out that someone else has done exactly what you've done 2 years before you. Now you've lost 15K. On the other side, you don't want to spend 50K of time and money to draft a patent application. A patent application should only cost you, a provisional should cost you around 10K. So you need to strike a balance. Depending on the nature of your technology, you should do some searching. If it's a recombinant protein, search the sequence, see if the sequence shows up in any other patents. Because if the sequence is being used in another patent, then you're going to have to add another piece, right? This diagram kind of illustrates, okay, if your exact 4 pieces in your arrangement comes in before you, then you're going to be invalid. So having an awareness of the prior art is going to coach you up on, okay, I need to add an extra piece, or I need to rearrange them a different way in order to eventually get to an issued claim. Because again, when this distinction between pending and issued, you can have any claim in a pending application, but through examination, an examiner is always going to say, oh, this claim is similar to 2 other applications. So you're going to have to add pieces, narrow your claim to get over the line. And real quick, before we go over to, actually, I did want to show you guys, because in the spirit of the Michelson Institute, and the Michelson Institute, I think, they're empowering entrepreneurs like yourselves to really try to, utilize a lot of free resources to advance your IP strategy. Ultimately, you do want to have an experienced IP attorney to walk investors or their investors IP counsel through your own IP strategy. But there are many tools to empower yourself. Google Patents. I use Google Patents at work all the time. You might be familiar with just a simple one search bar where you put in a number, but if you actually, there's a little pencil mark, and I can show you guys, but you can open a menu that looks something like this, and you can utilize these boxes to do very specific, to do more specific types of searching. If you don't utilize these boxes and you just put in a phrase, you might get like 10,000 results, and no one's going to look through 10,000 results. But if you can change this status, for example, to only issued patents, if you're only interested in looking for freedom to operate, let's say that Pfizer or Roche has a drug in your space, so you can narrow the assignee to Pfizer or Roche. And finally, if you know of certain inventors or certain PIs, you can put their names here, so it filters your results for specifically those things. Another great resource is going to be lens.org if you're in the biologic space. You can go to Lens, put in your sequence, and it's going to look for patent references. You can actually set your similarity and coverage, and it'll look for patent references that use use either all of your or part of your sequence based on the parameters that you input. Last thing I want to touch on, as we segue over to Ruben, is how to utilize university IP. I know a lot of you folks are current students or affiliates with universities. And really, when the question comes down to what do I do with this university IP, if anything, is go back to the investor questions that we talked about at the beginning. How is this company using IP to maintain its competitive advantage? And will these guys get sued? So going back to that diagram, sometimes that first family comes from the university, and that's not stopping us from building upon it. And, we've been talking about pending and issued claims, and I told you only issued claims are enforceable. The one positive about pending claims is that they can change. They can change in the US, they can change drastically. In the US, you can essentially change your claim. So this thing, claim number one, with almost anything that's in the entirety of the rest of the application. You can completely change, as long as it's in the application, you can import it into, you can delete what you had in the claims and import it into the claims. So when it comes to, let's think about the university, IP again, right? Can we, if claim one, if the claims, don't seem to be relevant to your product, is something in there? Can something be stretched, especially in the US, to cover your product? And converse to that is, okay, if we pass it up, can someone else, let's say Roche, who can afford the biggest, baddest law firm in the world, and afford for the biggest, baddest law firm in the world to work 24/7, can Roche take something from that specification and put it into the claims and create an issued patent? You got to ask yourself these questions, because if someone can do that, if Roche can do that, and you pass it up, and then you end up becoming $1 billion company, then you can bet that Roche is going to come back, find the university patent, pay $500 million, get the patent to block you, and shut down your company based on your own work. A lot of times, I have a PI who's spinning out a company, and they'll come tell me and say, hey, this thing I filed at MIT, I don't think anything's going to come out of it. It really just describes the pathway, and we don't need to look into this. But I don't want to spend, I don't want to pay these guys the royalties, and to hell with it. We almost never ever let it end there. For one thing, most importantly, what happens if a Roche takes it? What happens if you actually become $1 billion company and someone has a billion reasons to try to construe, make it work? And lastly, when it comes to royalties, we're always thinking about this, right? This first patent is going to expire someday, and if we've done our jobs, we're still going to have a lot of patent coverage and business exclusivity beyond the 20 years. So don't look at the financials of a university license. Should not, while they're important, it shouldn't dissuade you from engaging in that relationship if in fact we think that this application can support a concept that covers your product. We jumped around a bit. I do want to give Ruben a chance to elaborate on what goes on between the company and the university, and how you acquire those rights. But I do hope that someone here, or at least all of you, took something away, whether that's not prioritizing yourself, the two main questions that investors are going to ask about IP strategy, or really being, how to become aware of your kind of competitive landscape. What are the different ways of being aware of your competitive landscape? I'm happy to take any and all questions after Ruben's part of the segment. And thank you very much for allowing me to speak to you all.
Great, thank you, Mason. Amazing. And in fact, if you guys want to keep asking Mason questions in the Q&A, he can respond via chat. But of course, you'll be gripped by what Ruben's going to share with you. And I guess you can type your email into the chat also in case people you want to copy and paste. But and then you can stop sharing your screen, and then we can get Ruben to share his.
Want me to go ahead and start sharing?
Go ahead. Let me see if I can. Yes.
This will stop the other screen sharing. Okay, perfect. I'm just gonna share my entire screen. Before
make sure you tell us who you are and what general impression is.
Before I get started, I just want to say thank you very much, Steve, and the Alliance for this invitation. It really excites me to see the work that organizations like the Alliance and Nucleate are doing for the ecosystem, for the innovation ecosystem. And I want to congratulate all of you for being here. I want to make a recommendation. You don't have to follow it, but my recommendation is that I'll make my slides available. So you don't have to take notes on my slides, unless, of course, you have an aha moment and you want to make sure that you capture that aha moment. But I'm going to use the slides as a prompt to guide my presentation. And again, they'll be made available to you. Another point that I want to make before we get started that I like to make in these kind of presentations is that I just learned something amazing from some of the things that Maisem was saying, some things that I didn't remember. And I've been doing this for 22 years. So don't expect to become an expert by attending a webinar like this. We're here to tell you what are some of the elements and issues that you need to be aware of. But it would take you 10 years to become an expert and to do what Maisem is doing full time. And that would be a time that you don't have, that you'll be wasting. So part of the purpose of us being here is to tell you these are the things that you want to think about. But when you want to address these things, go and talk to the experts, right? I work with many firms like Maisem's. I have many colleagues in the field that I go and ask questions to all the time. So important to keep that in mind. This is to be aware of, some of the things that we work on and that you need to be mindful of, but in no way, shape, or form we think you're going to become an expert. I am with General Inception. I'll tell you about my background in a second, but I just want to do 2 slides on General Inception. General Inception is a new company based in Palo Alto. We are a C Corp that was funded by venture capital groups for the purpose, these are our inventors, for the purpose of taking early stage technologies coming from academic research, creating a company, de-risking that technology with our money and our expertise, and making that technology investable by an institutional investor within 12 to 18 months. So to secure a seed or Series A investment, that is the sole purpose of this organization. We started a couple of years ago. We have 25 companies that we've started, and our goal is to start another 80 to 100 over the next 4 years. These are our co-founders. Our co-founders and many of the people who work here at General Inception with me are active investors in other funds. And really the reason why this fund was created was to actually solve the perennial too early to invest problem that we have in this field that we all work in. About myself, I am got my PhD at UCLA back in 2000 in developmental biology. I never thought I was going to work in industry. I was going to become a professor. That was my plan. I ended up working 12 years in corporate America, in R&D, marketing, business development, in licensing, launching products, FDA approved products in the US, and also approved products in Europe and Canada. Then I spent 10 years after that in leadership positions at universities and technology transfer offices, including director at UC San Diego, associate director at USC, and vice president at Harbor UCLA Medical Center, the Lundquist Institute. So that's about my background, and I've been here at General Inception for the last 3 years. For the last 3 months, I'm sorry, I wish it was 3 years. It's so much fun. I'm going to try to share my entire screen. Can you tell me if that shows okay in the presentation? Wonderful. Again, there's so much to talk about. These are just going to be highlights. So let's get going, basically. So let's talk about the 2 cultures between university and industry. What I'm going to try to tell you today are some elements and aspects that you need to be aware of that you're probably not going to be able to solve in a lifetime, about how to work with university if you are in industry, and vice versa, if there are any people from the university here. So these are the different contrasts between university and industry, right? Universities have a societal responsibility. Industry have a responsibility of profit and loss driven to their shareholders. The university has an open-ended goal of research. The industry has very specific goals about the bottom line and product development or service. The university is long-term, industry we're much shorter term typically, and so on and so forth. So the 2 cultures are very different, and those are the cultures, and we're not going to change them. Okay, industry is not going to change university. University is not going to change industry. And if you start by accepting that, you're on your way to make your work easier dealing with universities. So what are the goals of academic licensing? And these are some thoughts. So, well, the goals is to facilitate the commercialization of research so products can get to the public, actually to reward or train and recruit faculty more and more, to induce closer ties to the industry. I gotta move my bar here. Okay, a big goal is more recently is to promote economic growth. That's a goal that many universities are starting to measure themselves by. Actually, they have been for the last 5 years. And question mark here, to generate income, really? And I'll talk about that in a second because the budget of a university, for example, UC San Diego, the annual R&D spend budget is $1.4 billion, and the income from licensing it's $6 million. It really doesn't make any difference in the budget. Now, from time to time, given the right conditions, a university has a breakthrough license or product that it's a multi-billion-dollar product that generates significant return to the university. Those are rare. Those come one in a decade for all the universities in the US. And so really the goal of generating income for the university is really not the goal of licensing. Industry, of course, wants to license to have the opportunity to develop and commercialize technologies. They want to negotiate a license that allows them to do this, that gives them the freedom, right, to take that product, that idea, that patent that Maysim just talked about, and do what you need to do in a more or less way that prevents you from having any surprises along the path. You want to create value, and to provide the university with a fair return. Well, question mark. What is fair? I mean, that depends on you. That depends to the university. There are no rules about this. Each case is unique. I'm going to go through this pretty fast. I don't want to go over the regulatory framework slides. I'm just going to show them to you. The point is that when universities are thinking about doing licenses to either a startup or an existing company, there are rules and regulations that the universities need to be mindful about that involve the federal government and the state. And these rules and regulations take effect the moment that a PI gets that grant. That grant usually comes with certain stipulations for the university and how to use any resulting IP. So I'm just going to show a couple of slides. BIDOL is a big component of some of the terms that tech transfer offices put on licensing. As a matter of fact, tech transfer offices really exist because of BIDOL. So I'm not going to go over that. I'll share the slides. Sponsor research agreements also have many federal considerations from the NIH and other organizations. So those are other considerations that universities think through legally in the way they can do sponsor research agreements. Private use, when you as a company wants to use the lab of a PI or collaborate with another person in an institution, there are also several considerations there that the university has to think about when they want to do this with you, but they have to think about how they can do it right. So again, I've been looking at this for 10 years. I have to think about it every time that I'm presented with a new case. Every case is unique. I'll pass along these slides, and let's get to the meat of this, which is talking about the license. Okay, let's talk about a license between a commercial enterprise and the university. And I'm going to be focusing mostly on startups because, this is, I looked at the list of attendees, registered attendees, and I saw that most of you were either professors or students working on, hopefully, in some cool startups that we all can help you with. So at a tech transfer office, sure, you are talking to the tech transfer office for a license, but you got everybody sitting at the table when you're doing that license, that collaboration agreement, right? As I say, the funding agencies have obligations, the IRS has obligations, there are certain policies that have bear on the license that you can get, IP, COI, consulting policies. The sponsor research office may have sponsor agreements that have bearing on the IP that you have. And then, of course, the PI, right? I mean, tech transfer offices, for the most part, want to work with the PI. Think about it this way. You may not like it. You may not be happy with the tech transfer office sometimes, but then they're going to be your best ally. If you try to circumvent or go around the tech transfer office, there's a much bigger chance that you're going to find yourself in trouble in the future, and trouble in a way that can ruin your business plan, can ruin company. Typically, it's not the tech transfer office that goes after an infringer, someone who took the IP out of the university with the license. Typically, it's a third party It's a third party that points fingers, knocks on the university tech transfer office and say, hey, look at this. This person should be named as an inventor. This IP belongs to the university or whatever. They're working in this lab. It's usually someone, it's really not the tech transfer office. I've never seen it. But once the tech transfer office is informed, they have to take action, right? They just can't just let it pass. So keep this in mind. Try to work through the system, consult experts. I want you to manage your expectations, right? The technology licensing officers have wildly different experience and motivations. We all come to this business from very different backgrounds. Many people come without any business experience. Some people come with a lot of patent experience. Some of us come to it with business experience. So each person that you're dealing with is going to have its own intrinsic set of knowledge and motivations. Try to work with that person, please, because that's your designated contact. Similarly, in the company, right? You may have, I wouldn't expect a postdoc or a professor to really know or be an expert on licensing, on licensing terms, unless, of course, the professor has done it for 20 or 30 years, maybe 25 years, then sure, right? But I wouldn't expect a postdoc that is just starting a company to be an expert on any of these matters. Keep in mind that technology licensing officers have very few resources to work with. The company lawyers may not understand the academic requirements and restrictions. Make sure that you're working with the right lawyers to help you with your license. Make sure that you use attorneys that have done academic licenses. That's super important. That's going to help you with, 80% of the issue. Most of the academic licenses get stuck not in the financial terms, but in other terms that we're going to cover really quick here. Productive agreements will be amended, usually 2 to 3 times, so keep it simple to get it going. So let's talk about a license. And again, I'm going to go really fast through this because we want to give time for discussions. Here are some typical terms and aspects that you want to think about when you're negotiating a license with a university, right? You want to think about the field of use, human, animal, device, whatever the field of use is going to be. You want to think about the territory, US, worldwide, Europe plus Asia, whatever it is, the IP and improvements to that IP. Those are tough to negotiate, but you want to think about those ahead of time. Typically, the license will have some diligence milestones. The universities are looking out for the benefit of society by asking you to show them that you're actually performing diligence in this license, right? The universities like to see that you actually try to fundraise, that you actually made some calls, that you actually build a prototype, right? So that's what the universities are going to put those requirements in there. Of course, there's going to be royalty provisions, and we can spend a year talking about what's fair, what's not fair. There are market common rates, and let's just think about using market common rates for different technologies. There will be other financial terms. There will be minimal annual payments that the university will ask from time to time, or sometimes, or all the time, depending on the technology. There would be equity. The university may ask for some percentage equity in the company. There would be sub-licensing revenue. If you take that license from the university and then you turn around and successfully license that technology to a third party, it is fair that both you and the university get a piece of that sub-license that you did. We can talk about how that's structured in a much longer discussion. There are going to be milestone payments. You got your product approved, you launch your product to the market, you did a partnership with someone else. There are many, many milestones that you can think of. They have to be fair for both parties, and they have to be milestones that, add value to the company, and that the company feels that it's fair to share those milestones with the university based on what the university brought to the table, right? Sometimes there's a change of control fee. If you get bought, sometimes the university will like to have a percentage or a piece or a fixed sum or amount from that acquisition. There are important provisions about confidentiality, assignability. You cannot just turn around and say, okay, I'm out, or I want this other party to take over this license and assume the rights and the responsibilities of the license. The university will probably want to make sure that that other party doesn't have any baggage, financial, legal, or otherwise, that may bring a bad actor to the table. Here, just very high level, right? These are some negotiable aspects of doing a license with a university, for example, due diligence and fees and royalties. So all the financials, that's what you are able to negotiate with the university. What kind of diligence do you need to do? But really, what's going to be non-negotiable with the university is who owns the IP, that you indemnify the university, that you use the name of the university to benefit your company. And oh yeah, in general, yeah, that you have to do due diligence, right? You can negotiate the specifics of what due diligence, but you have to have due diligence. Those are some non-negotiable terms with the university. I have a couple of more slides. How are we doing with time, Steve? Okay.
Yeah, you're doing great. Yeah.
Great, thank you. So, and again, you will have these slides. I encourage you to, just write down any aha moments that come to you. The scope of license rights, right? Is this going to be an exclusive license to you, only your company, or multiple companies are going to get access to this intellectual property? That is important to know. Now, multiple companies could get access to that IP and have those rights in different fields that are not competing with you, right? So you could develop a diagnostic for humans, and another company could come and do a diagnostics for animals using the same base technology. And most likely you're not going to be competing unless you have plans to develop, for example, the diagnostic in animals too, which you need to tell the tech transfer office ahead of time. So it's very important that you have very clear discussions and communications about your business plans with the university, because once the university understands those business plans, they're going to be able to offer you the best license that fits you. In general, again, I'm making generalities here. And remember what I told you at the beginning, each technology licensing officer has different motivations, levels of expertise, knowledge, and approach, right? We talked about the field of use, the geographic territory, and this is very important. Although you're licensing a patent, typically from a university, there's quite a bit of information, knowledge, processes, even data that resides in the lab of the inventor that doesn't necessarily make it to a publication or sometimes to a specification in a patent, right? So that's outside of the scope of the support information for the claims. But this secret sauce, this know-how, can also be licensed to your company. So you want to make sure that you talk to the university about licensing not just the patents, but the related know-how to those patents that exist in the laboratory of the inventor. The university will know what this is. They're used to doing this kind of licenses, and usually they'll offer you this from the get-go. But I want you as an entrepreneur to think about the fact that you are licensing much more than a patent from the university, and therefore you want to keep that relationship in good standing. Even if you don't like it, I mean, it's good medicine. It tastes bad, but it's good for you, right? You just have to go through that process. So improvements, I talked about this briefly before. Typically, universities will own their own improvements. If they're the ones acting and performing and discovering and inventing those new improvements or discoveries by, and this is where Megan can help me, by patent law, the inventors reside at the university, the inventors assigned to the university will own those improvements. And there's no guarantee that the university will license those to you unless you have a good relationship with the university, right? So it's always important to have that good relationship with the university. So, however, you can seek to license or option to license improvements. You can tell the university, hey, why don't we at least agree that if you can, university, you will agree to negotiate with me in the future to license these improvements. At least you can have that in a piece of paper, and that can give your investors some level of comfort knowing that, okay, at least we have an option. The university is open to talk to us. It's not like university is never going to talk to us about those improvements, right? That's an important aspect of follow-on IP development that ties into what Mason was saying. If granted, funding sponsor research. Right. So again, this third sentence that I have here is very technical. It has to do with the type of funding that goes into that improvement. It has to do whether that funding has any prior commitments to other parties. So It's not entirely straightforward to understand, and the university will work with you and let you know if they can actually license those improvements to you or not. If they have the ability, the legal ability to do it even, because sometimes they don't. Okay, let's talk about a little bit about diligence and milestones. For example, I'm just going to jump into the here. Use reasonable efforts to develop XYZ you're doing. So basically, if you show the university that you're behaving more or less like any other startup is behaving, and fundraising and doing experiments and advancing the program or the research or the de-risking, whatever you need to do, the university is going to be fine with that. And it's in your own interest that you write what you think are those milestones. As a matter of fact, that helps you think through your business plan, right? And we all know that a business plan is going to be, as soon as you finish it, you throw in the garbage, and that's not going to be the real business plan. But organizing your thoughts, going through the process of thinking, what are those milestones, right? Is what's going to help you prepare for what's coming. So FDA filings, first commercial sale, those are kind of standard milestones that the university kind of likes to negotiate some compensation around. And also the date with the company will raise X amount in funding, right? You actually committing yourself to do this raising, this fundraising. Now you tell the university, okay, in a year, I'm going to raise $500,000. 2 years, maybe 750, or I'll do $500,000 in 2 years. Whatever you think your real plan is, be realistic, right? Don't promise things that you cannot do. But also keep in mind that if you thought you were going to be able to do something and you don't achieve it within the timeline, you can always go back to the university and say, hey, here, let me show you my diligence. I did what I supposed that I was to do. Unfortunately, didn't hit my goals. I need more time. I need to renegotiate with you. And typically the university will do that, will renegotiate. Unless you come 3, 4, 5 times, then, that may give pause, right, to the university to continue the license. Milestones should be few, clear, and unambiguous. You should write them. You should be realistic, right? And then if you miss the milestones, typically several times, right, that can result in a termination of the license or conversion from exclusive to non-exclusive from exclusive, right? There are many scenarios. There are no rules. It depends on how each license is negotiated. So I think I'm just gonna, this is probably what everybody wants to know or wants to talk about. Royalty rates. The royalty rate is independent for each deal. My recommendation to you is don't go and tell a tech transfer office, I want 3% because that's what I've heard you give this other deal, or I want 5% because that's what I've heard that's what the industry standard is. You can say, hey, I believe that this is a fair number because X, Y, Z. But the university is going to tell you, hey, actually, you're right, or actually, no, this technology has all these other differentiators or these additional characteristics that are missing from the example that you gave me. So it's good to come in informed, but don't really, throw just a number out there because someone else got that number, right? Each deal is unique. Stacking provisions are provisions that allow you to discount the royalty that you give the university based on other IP that you have to pay to third parties, right? So if you license multiple IP, you are paying royalty to those other parties that you license the IP, the university is going to allow you to get a discount on the royalty that you give. Also in combination products, you will get a discount. There are discounts on volumes, right? Step up or step down. After $10 million in sales, you only pay 2.5 instead of 3. Or after X amount of volume, you start paying more royalties because we gave you a really low, royalty rate initially, so you can ramp up. It depends on how the deal was negotiated. Okay. Pay attention to the definition of net sales. So I think I should probably stop here. What do you think, Steve, or should I keep going? I have three more here. Maybe we just leave it. Okay.
Yeah, go ahead. Yeah, that's fine.
Okay.
Yeah, let's see what kind of questions we have. I know we have one question from Carson Folk, who I was going to have come up to ask his question from Nucleate. Let's see if that works. Oh, Carson, now, sorry, I think you are now on.
Hey, Steve. I actually had two quick comments on two things that Ruben had brought up. I think it'd be kind of important for everyone. And thank you so much, Ruben. This was really breaking it down. This is also invaluable information, everybody. Really pays to kind of have these expectations and know these things before you enter into these kind of negotiations. But one important point of the many important points that Ruben made on exclusivity, exclusive versus non-exclusive. We talked about, what are the two things investors ask? Making sure that you're protecting your products and making sure you don't get sued. When I say protecting your products, what exactly does that mean? That means if someone does rip you off, you're going to assert your patent against that other person. And in order to, if you're asserting a patent that's licensed, you need to ensure that you are the sole entity that has the right to practice the patent in the field. So that's kind of important. If in the universe, if you agree to a non-exclusive license and it turns out that this university or this company has licensed the same patent to a couple other folks non-exclusively, you're not going to be able to sue someone unless you get all of those other non-exclusive licensees to join you in the lawsuit. Now, sometimes the university license, it might provide for that, saying, hey, if X, Y, and Z happens, everyone will join you. But in practicality, it's not always that simple. So that's an important aspect of an exclusive versus non-exclusive license.
And yeah, talking about an exclusive license, here is what typically an exclusive license contains, right? And we went over some of these terms earlier in the last few slides, and I just want to kind of tell you that for an exclusive license, typically you see an upfront fee or equity or both, minimal royalties, annual maintenance fees, milestone payments, patent expense reimbursement. We haven't talked about this, but if you're going to get that exclusive license from the university, it's your IP. Now you own it, but with the ownership comes the expense, right? So you buy an expensive car, got to maintain it. You got to pay for the tires, you got to pay for the fuel. So you get that license, that patent is yours. So something that sometimes you can negotiate with universities is the choice of attorneys to do the patent prosecution. Typically not, but sometimes you can. So if you have you believe you have a better firm, cheaper, faster, you can tell the university, okay, it's my patent. I want this firm to do the work, right? Because it's going to save me money, time. They're going to get me a patent faster. They're experts in this or whatever. So it's worth having that conversation with the university. And typically, a license, an exclusive license has sub-license income, right? A percentage of all payments from sub-licensee, not only non-royalty payments, but you can actually negotiate carve-outs. What is income for you? Well, when somebody pays you, you're a startup and a big company pays you, I'm going to pay you $5 million for you to do R&D. The university really should not get any, percentage of that, because that was given to you to carry on a particular R&D project, right? Or somebody comes and does an equity investment on you, right? It would be hard for the university to get part of that investment that someone else did on you. I'm sorry, I think there was a question. Was there a question from someone?
Yeah, briefly. I was wondering if there's any particular benefits to creating a provisional patent with TTOs. What would exactly happen if you went through this independently, et cetera, et cetera?
Could you refresh your question again, please?
Sure, yeah. Are there any particular benefits to a provisional patent through a university TTO? What would be the benefits that you would receive through, say, working through a university lab versus doing it by yourself?
Can you afford to do it by yourself?
There are so many ways to answer that. Yeah, that's a great question then, as a math, right?
Yeah, that's my knee jerk, Carson, is can you afford to do it by yourself? Do you have the next question is, do you have the expertise to do it by yourself? Well, another comment I was going to make after Ruben's speech was another important thing that I think doesn't get highlighted is most cases, you're not just licensing technology, but you're really starting a relationship. And you got to ask yourself, how am I going to, what does this relationship mean to me? You know, and you need to properly use that relationship in the best interest of your company. If you don't have the resources, then you're going to need them for a lot of things. If you do have the resources, but maybe there's just a little bit of expertise you're missing, then it might call for a different type of license terms. Maybe it's not a license you're looking for, and it's something else, like a consultancy or something like that. Many different ways to answer this question, but Ruben, do you want to take a stab at?
No, great points. And I actually removed from my presentation, I have like 20, 30 slides that I removed from this. This is an hour presentation that I tried to consume into 30 minutes or less. I'm sorry. But there are other ways of working with the university. But the question is, if you ask me, okay, Joe Smith comes out of, his garage with a patent, with claims, or Professor, XYZ from Caltech, UCLA, or any university comes to me, and I'm looking at the claims, at the patents, and it's not only the IP, but it's also well, where is this going to go? How is this going to evolve? Does this PI has the resources to go and continue to develop the IP? Investors are naturally going to gravitate towards a known entity, right? So the benefit that you get from working with the university is that it's a known entity, right? You know what you get. There's less risks than if I invest in a person that I don't know. The IP is associated with the university. I know that there was some level of diligence that the university had to do to file for the IP. So that is my answer to you. Again, it's a business call, and like Mason said, if you can go ahead and do it on your own, knock yourself out. By all means, do it. Now, keep in mind, again, depending on what you're doing, if you are a university, depending on what you're doing outside of the university may actually have claims to your invention outside of the university if it falls within the field of while you're working at the university, right? So you want to be very careful about that.
You need to be this is the University of California's, but if you're at a company or a university, any sort of entity or institute, you need to be familiar with your patent policies. Generally, it's, if it has to do with the stuff that we hired you to do, or if you're using our resources, using our time, then we're going to own it. Generally, there's a little bit of differences, but that's the general idea. So another, going back to your original question, Carson, you can't, work on something in your lab or your PI's lab, and then, hit up MASAM and file a patent application in your name. I mean, you can do that. There isn't some ghost who's going to stop you from doing that. But what happens is, let's say everything goes according to plan and your wildest dreams come true and you becomes $1 billion company. Probably before that moment, but somewhere along that line, the university's gonna be like, hey, this looks like what Carson's PI was doing, when Carson was a PhD student. What was the date that he filed this? Wait a minute. I think, and then at that point, the university is going to shell out for one of the biggest, baddest law firms out of their budget and recoup on those billions of dollars they lost.
And as far as I understand, it also extends into if you're working in the lab and you're just doing some light reading as well. Yeah, it was a really great point that I think Ruben made, that universities offer a certain amount of credibility for VC firms and funding that individuals don't really have. So yeah, there you go.
There were 1 or 2 questions in the chat. There's one now just about using public databases like Google and Google Patents. They do kind of track what you search, and they provide suggestions. So are there any general concerns with using Google about them, stealing your ideas, learning about your concepts? Is that a concern or no?
Just think about the amount of Google and filings that Google would have to do. They were stealing everybody's ideas, right? So I don't know. I mean, that's a question from my side, but it just strikes to me that probably Google can probably monetize that. They probably monetize that information, but probably in a different way, not by going against you. They probably create some kind of trends. If I was Google, I would create trends, key search terms, where things are going, how do people react when they get certain results presented. I mean, that's what Google's business is, right? Amazing.
Yeah, I attempted to answer this question with kind of, typing it out, but there's a couple different angles of attack here. But what I tried stressing in the text was, you got to ask yourself, what are you concerned about exactly, right? And what are you putting out there in your search terms? And how does, like, for example, I think it's okay if I share this. I don't think it's confidential. But if we're, if your search strings look like this, are we seeing are you guys able to see the PowerPoint?
We're seeing a
Yeah.
PowerPoint with terms I don't understand.
Exactly. If it looks like this, and then as I told you guys, as I showed you guys during the meeting, the claim, right? An issued claim looks like this. And then, as Ruben mentioned, there's a whole other boatload of know-how, and there's another logical leap of actually practicing the technology and doing the technology. So what I meant in my first comment was asking yourself, like, what am I scared of actually getting put out there? I mean, frankly, there's going to be a lot of other people that are using, that are working in your general space, using, that their technology is probably going to also be implicated by the same key terms that we just looked at. I mean, even in my example, there was like 24,000 references based on one of those strings, right? So, for one thing, let's take what Ruben said, and just, if they're actually going to act on it, there's an unfathomable amount of data they're going to have to sift through. And two, the data that you've put out there in the public domain, what exactly is it telling people? But I'd be more than happy to have extended conversations about this, and to more clearly, like, hear out your concerns too, because this is interesting.
Cool. Awesome for those response. Another question I think is worth highlighting is just generally, like, when is the right time to file a provisional patent? So from tech transfer offices, I've heard, pretty much when you're making your manuscript, come to us with the manuscript before you publish it on bioRxiv or anywhere. And that's a good point. But I also hear the flip side, some PIs and whatnot are like, oh, this is a very competitive field. We're working on XYZ CRISPR thing. Other people might be filing. We should just submit a provisional because it doesn't cost that much. And, I'd rather get something on the book. So what's sort of like the back and forth between getting something on paper early just to be the first to file that versus waiting for actual data? I know you made the point of, you have to make a non-provisional within 12 months. So ideally you have data within the next 12 months. Is that the real mindset? Do we have data in 6 months from now? And, how realistic are PhDs and professors at, predicting how long out they need before they have good data?
Great. Ruben, I'll take the first stab. And I'll preface it, I hate to plug myself, but I do have a YouTube video on kind of the disclosure requirement for patents. And it does talk about, like, timing and when do you think you have enough to file. So it's a good half an hour, 45-minute discussion on that. But to sum it up, my rule of thumb is to file a provisional application when I'm at a stage where I think I can develop reduce proof of concept data to practice within 12 months. So within that, by the time I need to convert to a non-publication, I have several examples of reduction in practice. That's my general rule of thumb. So that means that on day 0, the day of your provisional filing, what's essential that you need is a description of the structures that you want to protect. Maybe you don't know exactly what they do or how they do what they do. And maybe you don't know the perfect arrangement, but you know that, if I take some sort of arrangement of at least 5 of these species of 100 molecules that I know about, some sort of, X pathway gets augmented, you want to at least put down those structures, the species, and maybe write out how you're going to test them. You don't even need to do that. Just the species and how you're going to use them. And then within the year, you want to back that statement up with the reduction of practice data. In a not ideal situation, but a workable situation, is you can still convert it. Let's say you don't have the data, but you're about 6 months out, 4 months out, you're close, right? What I would say is, let's not relinquish, because you have two options. You don't have to convert, you can let the provisional lapse and your date, and then you refile it, but then you get a new date. So anything said in the last year can now be used against your new date, right? But what I would suggest is, instead of relinquishing that date, convert the application, but describe prophetically what experiments we're going to do. Like, let's say we haven't done the experiments, but we have the protocols. Write the protocol into the application. Predict the data. That's okay. We can do that. And then you can actually, if needed, bring in the data post-filing in response. You can't add it to the application, but if called upon in a rejection, saying like, hey, these are novel structures, but the data that you may or may not have isn't convincing, you can actually bring in post-filing data. I think that covers it. So just to sum it up, file when you're within a year. Generally, file with it when you think you're within a year of being able to produce data or reduce it to practice. And the earlier the better. So that's why I'm giving it's aggressive advice.
It is aggressive advice, right? And in general, in practice, that's what most tech transfer offices would like to do, right? I mean, you typically don't have a 1-year deadline before you publish a manuscript. I mean, it happens, but typically not because of you want it that way, but for other reasons. But it's going to happen within 6 months, 4 months if it's fast. So yeah, I would just heed the advice of the tech transfer office again. And don't take this wrong. The tech transfer office works on this day in and day out, and they see hundreds of cases, right? Many different examples. So hopefully, your tech transfer office will know, or if you don't, here's some advice. If you don't necessarily trust 100% the advice of your tech transfer office, but you have to work with them, tell them, hey, could I talk to the attorney? That you guys are using. I like to talk to them about and see what the attorney says, right? So don't leave it on your own to guess. Go out, talk to the tech transfer, and if you want to ask for the opportunity to talk to the attorney, like, each tech transfer office has typically several law firms that, they use, but don't try to guess it yourself.
Awesome. And then we have time for one last question. I know that there were a handful of questions just around cost. So could you just give kind of a brief idea, maybe not just your firm, but like kind of industry standards for how much does it cost to do a patent search? How much does it cost to do a provisional filing? How much does it cost to convert to non-provisional? And then just kind of basic, like how long does it take to go through the patent process? Every time the patent office says no, and how much does it cost to respond, and general timelines.
All right, that was a lot of questions there, Brian, and a lot of estimates. But is my PowerPoint still showing?
Yep.
Okay. A lot of numbers going on, but I'll try to hit each and every one of those. Typically around 10K for a provisional application. That's at Wilson Sonsini. I think there are other firms that can do it for a bit cheaper. Many reasons why you want to have a robust provisional application. Doesn't necessarily mean we have data, as we just talked about, but we did say we want to at least have all of the different structures and variations of the structures. So it's very easy for someone to take you say, hey, these are all the things I want to protect, and you just put them on a piece of paper. But for $10,000 and with some time, I can, our technical experts, who also have the legal expertise, can do their own research and figure out what are other ways. If these are the things that this guy is saying can work, what else can work? What are some, conceivable adaptations? And you want to get coverage for all that in your provisional. So that's why you want to have a robust provisional. Cost around 10K. When it comes to conversion time, there's going to be around $5,000 of hard costs to the government, and then however much more time you need based on how much you need to update. So about $5,000 going straight to the government, and then the rest is going to be variable. But Ideally, the way Wilson Sonsini writes their provisionals is that provisional, the data was ready. It's not one of those situations where, hey, the data is going to be ready in a year. They already have the data. We wrote that provisional with the intention of, hey, we can convert it tomorrow if we want to. So really the 12-month budget is only just the 5,000 hard costs of getting the conversion. Now, at 12 months is where you can start examination if you want to. Okay, examination starts at your non-provisional filing. You don't want to start, and you want to wait till your 12-month deadline to start your examination, to file your non-provisional, because your term, your 20 years, as it said on the first slide, starts from your earliest non-provisional filing. We're allowed 12 months of provisional status. Use those 12 months because your expiration date is the most important thing, and that's set in stone. That's going to be set in stone based on your non-provisional filing. You want to use your last absolute day. So once you start prosecution, and this is it's a wide range, almost anything can happen, but typically we see between 25 and 35K from start of examination to an issued patent. And typically that's stretched out between 2 and 3 years if you don't do any acceleration. When a company is just starting out, if the budget allows, I like to accelerate the prosecution of the first application so that we have an issued patent to show investors, hey, we have one issued patent, we got a ton more on the way. We just need a little bit more funding to push these along, right? If you accelerate, it's about a $5,000 upfront fee. Then that 25 to 35 gets compacted into a year. So it's not cheap. Lastly, as I mentioned earlier, is that patent protection is country by country. So when you get to this 30-month date, that's why we see this awful 100K number, because you're going to have to pay a filing fee for each country that you want to enter. And then once you've entered that country, it's back to that prosecution. Now, granted, it's not de novo prosecution, right? Patent laws are different between country to country, but they're generally the essence of the laws are the same. So not exactly, but if we have like a lead case, like if you accelerate your US here, 2 years later, you're here and you have 1 or 2 issued US patents, you can use those as you're not reinventing the wheel in every country. But there's going to be transactional costs involved with maintaining the applications in each of those countries. Typically, the goal is, you bootstrap your provisional, you get some friends and family to help with the conversion, and then you show off your non-provisional converted application to investors, and you secure some actual VC money by this 30-year mark, so you can afford to go wide. As far as search, we haven't talked about searching. Now, there's a couple questions about searching. Patentability searching, freedom to operate searching. Similar, not exactly the same. You want to do patentability searching before you file your application. You want to do freedom to operate searching when you're asked to by an investor, or you're preparing to go in, or you're preparing to go ask for a large check. That's when you want to do your freedom to operate searching. The patentability searching costs, frankly, those are built in to these estimates. You don't want to spend a provisional application should cost around 10 to 15K, no more than 15. You don't want to spend the equivalent of 50K. Like, it's just not, you should use that time and money to build a better application, not doing the searching. Okay, but that being said, you want to at least know of some of the prior art, so you're basing your claims off something, right? And lastly, when you do this conversion, you have 2 options. You can either go US only or a PCT application, which is your international placeholder. We always say PCT because you want to go international, A, but B, you get a non-dispositive search when you file a PCT. So I have a lot of companies that, because they're very early and they won't do any freedom to operate, and they'll actually rely on that first PCT search report to introduce some of the patents in the field. And then maybe you can use those patents, you get a starting position. You can use those patents to get to other patents, so to speak. The freedom to operate, it just varies. It's a function of the check size. If you're doing, anywhere with like a couple million and over, a couple $1 million fundraise, you want to put in like a 20K FTO. If you're doing like, $20 million fundraise, you want to put in like a 50K FTO. If you're early, sometimes depending on the nature of the technology, again, like predicate device, perhaps for up until, that $50,000 FTO, maybe all the investors are looking comfort for is, hey, can you just make sure that the patents covering your predicate device are expired or aren't relevant to you? If you're commercializing a novel, some new peptide, right? Perhaps all you need is a $5,000 to $10,000 sequence search. And that's going to give investors up until commercialization comfort, right? So the freedom to operate is going to just depend on where you're at as a company and what your investors are asking you for.
Awesome. Thank you for that. I think that is about it for our Q&A session. Steve, you want to wrap it up?
I have one last thing, like literally 20-second stuff that I want to say. Is that okay, Steve?
Oh yeah, go ahead.
Let me go ahead and share here real quick. I'm sure some of you know, but some of you may know that in addition to a license, what you can also negotiate with a tech transfer office is an option agreement. An option is basically a period that allows you as a company to have some kind of exclusive rights over that IP, but you don't have to negotiate royalty rates, payments, any of the above. Basically, it's kind of like a trial out period. You're going to pay a little bit of money, a lot less than a license. You may be asked to pay for the cost of the patents just during the period of that option, but that's something that actually may give your investors confidence to invest in you as well. That's another tool, and you don't have to do the full license now. Talk to your tech transfer office and see if they offer that option. Okay, that's all.
Great point,
All right.
Ruben. Great. Saying I have an active exclusive option with the university is an effective de-risking strategy to an investor.
Right, and you don't have to negotiate a full license.
Right.
All right. Well, thank you so much, Mesam, Ruben, and Brian, and thanks, Carson, for asking a great question. You're still up on screen, but which is great. And that was my doing. So great. Thank you all for sticking with us and joining us today. And this is recorded, and we'll be posting it soon. So if you missed anything and you want to have your friends listen to it, please do pass it around. We'll be sending an email to everyone using the email address you register with. So take a look for that. In the meantime, thank you all, and this has been a Alliance Nucleate Michelson IP production with help from Wilson CD and General Inception. So thank you all very much.
Thank you very much. Enjoyed it. Bye.
Great. Bye, everyone.
Thank you all.